Private property is thus an extension of the right to use unclaimed things. Grotius understands this extension in a very precise way. It is an extension from the right to use the things that are seized to the right to recover possessions after seizure. Occupation must always begin with an active seizure, that is, with physical attachment or connection of body with body. But with respect to those things that are seized, but not immediately consumed, it must be decided how long and under what conditions ownership is to continue. Grotius is here asking Locke's famous question in reverse. Locke observes, "He that is nourished by the acorns he picked up under an oak, or the apples he gathered from the trees in the wood, has certainly appropriated them to himself, but body can deny that the nourishment is his. I ask then, when did they begin to be his?" Grotius agrees that these things belong to whoever has appropriated them. But he asks the question, when do they stop being his? His answer is that for most things it is enough that after the initial act of seizure, the intention to possess is maintained, for example, by the erection of buildings or some determination of boundaries such as fencing in. Wild animals and other things that are resistant to seizure are exceptions, and for these things actual physical possession must be continually maintained. Grotius elaborates on this in De Jure Belli, where he says, once again, that ownership begins with actual physical possession and continues as long as it can be inferred that the owner has not abandoned ownership. In the case of escaped animals, ownership is lost because of the natural inference that we have abandoned ownership. But he adds that even in the case of wild animals, it is possible to attach identification marks to those we capture to indicate our intention to maintain ownership by recovering possession. The significance of these requirements is not, I believe, as Tuck thinks, that occupation requires labor of some kind. Rather, we must stake out the land we wish to occupy, and we must mark our animals in some way to indicate to others that our intention to recover possession. Taking beyond use is not forbidden in the natural state, but that which is taken or transformed by labor is not private property, but there is no right to recover possession. For example, laboring to produce or collect food for future consumption is not forbidden, but after it is produced or collected, the food effectively reverts to the common if physical possession is not maintained. Similarly, taming wild animals is not forbidden, but there are no rights attaching to animals beyond possession. So, although occupation has a natural connection with seizure and consumption, it is introduced by reason and decision, and it cannot have an effect on others unless it is accompanied by acts that others recognize as indicating the will of the occupier. It is for this reason that Grotius says in De Jure Belli that the introduction of private property could not happen by a mere act of will, because one could not know what things another wished to have in order to abstain from them, and besides, several might desire the same thing. Rather, things became subject to private ownership by a kind of agreement, either expressed as by division or implied as by occupation. Pufendorf and Locke. In Mare Liberum, Grotius has said that neither sovereignty, meaning a particular kind of proprietorship, such in fact that it absolutely excludes like possession by anyone else, nor common, meaning ownership or possession by several persons jointly according to a kind of partnership or mutual agreement from which all other persons are excluded, apply to the original state of the world. Common originally meant the absence of proprietorship, and sovereignty meant the privilege of lawfully using common property. It is not the case, therefore, as Schlatter maintains, that common possession meant for Grotius a kind of joint ownership that had to be dissolved by agreement. Moreover, Pufendorf endorses Grotius's account of original community when he says, Grotius rightly maintains that if this kind of negative community was to continue without disturbance to the common peace, men had to live in great simplicity. Pufendorf's only disagreement with Grotius is over Grotius's remark that community could have continued if men had lived on terms of mutual affection, such as rarely appears. Pufendorf says that this confuses negative community with positive. However, Pufendorf here misunderstands Grotius. Grotius says that the original community can only last as long as men live without toil, and since his discussion of the problems of gathering the products of the soil into a common store are about unfairness with respect to labor, he cannot be talking about the original common. Schlatter also misdescribes the nature of Pufendorf's agreement by separating the process of acquiring an obligation from the renunciation of prior claims. Pufendorf's negative community is an inclusive state to the extent that all have equal natural faculties, or indefinite rights, to every part of the common. Thus, a man acquires an original right over things when all other men expressly or tacitly renounce their faculty to use a thing which they had held before on equal terms with him. So when one person acquires the use of any part of the common, all others must renounce their faculty to the same. The first taker's faculty becomes a right, as all the others renounce their claims and thus come under an obligation. Despite the fact that Pufendorf insists against Grotius that the first use of the common requires a convention, it was not his primary intention to refute Grotius's general theory. Rather, as Thule had pointed out, Pufendorf was defending Grotius against a number of critics who, Pufendorf says, have confused negative community with positive. The general point that Pufendorf upheld against these critics was that as long as common property is understood, as he and Grotius defined it, there is no contradiction in saying that God gave the world to men in common and that they are subsequently introduced proprietorship on their own initiative in keeping with natural law. Beauclerk, for example, argued that only proprietorship can have the effect of lawfully excluding others. So when Grotius said that there is an original universal right that enables people to lawfully use the common, and that this universal right took the place of proprietorship, he contradicted himself. Pufendorf defends Grotius by saying that the first universal use of the fruits of the common was not proprietorship, because proprietorship is the right to the substance of the thing. So he says, following Grotius, that a universal use of the thing in some way took the place of proprietorship. However, the phrase "in some way" is significant and reflects Pufendorf's inability fully to support Grotius's theory. Although a proprietorship is not the same as the universal use of right, both, according to Pufendorf, require an agreement of some kind because both entail exclusion, and to this extent, to use Tuck's phrase, they are not categorically dissimilar. Pufendorf thus provides only partial support for Grotius in his reply to Beauclerk by saying, "In this, as it were, limited community, the bodies of things belong to no one, but their fruits, after gathering, are proper." Such a tempering of primitive community with proprietorship, I feel, is comprehensible even by men of ordinary intelligence. Pufendorf thought, therefore, that the Grotian position could only be preserved against its critics by modifying it to include this first convention. The only way of preserving the Grotian theory that God gave the world to men equally against the alternative view that it had been given in the form of private property to the first man was to construe any kind of use of the common as conventional. As we have seen, however, it is Tuck's view that Pufendorf's revision of Grotius amounted to a repudiation rather than a defense. While it may have preserved an intelligible notion of common property, it did so at the cost of undermining what had been a crucial feature of Grotius's original theory, namely, that the primitive use of right did not presuppose a prior agreement of any kind. Tuck is correct to the extent that if the revision was necessary, then it had far-reaching implications. However, Grotius's theory, as I have interpreted it, did not stand in need of Pufendorf's defense. Grotius had shown how it was possible for the common to be used without an agreement and without the existence of any prior right to part of to the common. and he had shown this without claiming that the act of using the common creates new rights in it. For Grotius, God had given the world to men so that they could use it without having to agree beforehand precisely how they were to use it. It remains for us to consider the relationship between Grotius's theory and that of Locke. The usefulness of claims about continuity between different authors in the natural law tradition depends on the degree of generality of themes under discussion. Grotius had argued that God had given the world to all men in common, and Pufendorf had taken up this position in opposition to the Adamite theory, which held that God had conferred private property on the first man. Locke defended the same position against the same adversaries, so from this point of view there was an important common ground between three authors. When we consider the difference between them, however, then in view of what has been said above, it is hard to support Schlater's contention that Pufendorf moved the natural law theory of property in the direction of Locke's theory. Far from being a step nearer to a theory of property, which would dispense with agreement and conventions altogether, Pufendorf's theory added a convention, which, according to Grotius, had been unnecessary. Thus, if we are seeking a possible predecessor to Locke, Grotius, as Tuck argues, is a more plausible candidate than Pufendorf. However, Tuck claims about the relationship between Grotius and Locke go further and are more specific. According to Tuck, de jure belli is Janus-faced, and its two mouths speak the language of both absolutism and liberty. The absolutist arguments follow from the contention that rights enjoined in a state of nature are given up by agreement, with the result, as Tully remarks, that men in civil society cannot appeal to a natural standard of property to criticize and oppose prevailing forms of property. The libertarian arguments follow from the principle of interpretive charity, which requires us to consider what kind of agreements reasonable people might have made in the past. While it remains true that our rights and duties are always to be understood as formed by interior agreements, it is nevertheless the case that we must be generous in our interpretation of those agreements. Thus, in relation to the agreement to establish private property, Grotius says, we must in fact consider that what the intention was of those who first introduced private ownership. And we are forced to believe that it was their intention to depart as little as possible from natural equity. Hence it follows, first, that in direct need the primitive right of use revives as if community ownership had remained. According to Tuck, however, it had been unnecessary for Grotius to rely on the principle of interpretive charity to produce this radical conclusion, but it fell to the far-sighted Locke to see this. While Grotius has felt constrained to use the interpretive charity to justify the right to seize commodities necessary for life, Locke realized that a theory of property of the kind Grotius advanced in Mare Liberum, and which is still fundamentally present in de jure belli, need no such additional principle to generate a right of that kind. As evidence for this claim, Tuck cites Locke's so-called spoilage limitation, which Locke states in reply to a possible objection to his theory of appropriation, namely, that if gathering the fruits of the earth make a right to them, then anyone may engross as much as he will. Locke says, the same law of nature that does by this means give us property, does also bound that property too. God has given us all things richly, 1 Timothy 6:17, is the voice of reason confirmed by inspiration. But how far has he given it to us? To enjoy, as much as anyone can make use of to any advantage of life before it spoils. So much he may by his labor fix a property in. Whatever is beyond this is more than his share, and belongs to others. Tuck remarks the clear tenor of this passage is that the industrious poor are always entitled to the wherewithal with which to make their livelihood, while societies can make explicit and positive agreements about the distribution of property. These agreements cannot override the general rules rules concerning the exploitation of the world by mankind which God laid down. This, according to Tuck, was the radical conclusion that Locke detected would follow from a Grotian theory of property, and that made the principle of interpretive charity unnecessary. Leaving aside Tuck's controversial interpretation of the spoilage limitation, it is certainly the clear tenor of Locke's whole theory of property that people are entitled to the means of their preservation. Locke begins chapter 5 of the second treatise with the statement that natural reason tells us that men, being once born, have a right to their preservation, and consequently to meat and drink and such other things, as nature affords for their subsistence. One way in which this natural right to preservation can be exercised is by laboring on the raw materials that God has given to mankind in common, but it is not the only way. In the first treatise, Locke says, "As justice gives every man a title to the product of his honest industry, and the fair acquisitions of his ancestors descended to him, so charity gives every man a title to so much out of another's plenty as will keep him from extreme want, where he has no means to subsist otherwise." Haunt and Ignatieff interpret this passage to mean that the excluded have only an imperfect right to the surpluses of the rich. The obligation on the part of the rich was left to the individual. It was a side constraint rather than a structured condition. Other interpreters, however, think it means that the needy have a perfect right, which follows directly from the fundamental right to preservation. On this view, charity, in addition to labor and inheritance, is one of the ways in which man's natural rights to preservation can be exercised. Tully, for example, says, "The man's need creates a title in the goods of another, thus individuating his natural rights not to be excluded from the means of preservation. Thus, a proprietor who has more than he needs for his own preservation is under a positive duty to sustain those who do not." Ashcraft also says that the natural right to preservation corresponds to a duty that everyone is under to provide for the subsistence of everyone else, where this does not come into competition with a person's efforts to provide for his own subsistence. And Waldron similarly argues that people who have more than they need are not at liberty to let others starve. Locke says, "Everyone as he is bound to preserve himself, and not to quit his station wilfully, so by the like reason when his own preservation comes not in competition, ought he, as much as he can, to preserve the rest of mankind." This doctrine, according to Waldron, imposes positive duties on men to satisfy others' needs, or at least stand aside while the needy make use of property acquired by those who are not needy. And these duties are correlative to the rights of the needy. Thus, private property rights are constrained by a deeper and, in the last resort, more powerful general right which each man has to the material necessities for his survival. There is disagreement, however, over the scope of the right of charity. Srinivasan takes issue with the authors cited above and argues that charity is not due in virtue of need per se, but in virtue of need generated or made, pressing by an inability to labor. The right to the means of preservation is not, as Tooley, Ashcraft, and Waldron think, a consumption right, but a right to produce subsistent quantities of meat, drink, and whatnot, that is, a right not to be excluded from the use of the common materials which have been plentifully provided by God. Charity, according to Srinivasan, applies only where a man is unable to labor. Nevertheless, Srinivasan does not deny that charity and inheritance also constitute titles to the means of preservation. Locke's right of charity, therefore, interpreted as a perfect right, is grounded in the inclusive natural right that all people, being once born, have to their preservation. It is thus a different kind of right from Grotius's right of necessity. In Grotius's theory, there are no natural entitlements, either to the means of preservation or to the wherewithal to make the means of preservation. There is merely a right to make use of things that are not being used by others. This This used right, no doubt, ensures that everyone is preserved as long as they are content to live the simple life, but there is no right to preservation, which, to use Tully's phrase, is operative through time. That is to say, a right that cannot be overridden by subsequent agreement. Nor in Grotius's theory are there positive duties of charity, which oblige us to assist others in distress. Grotius insists that the ground of his right of necessity is not, as some allege, that the owners of a thing is bound by the rule of love to give to him who lacks. And he underlines this when he says that the right of necessity is a question of what may be done against the will of an owner. So if, like Tuck, we take Grotius to be saying that occupation is non-conventional, and that it merely requires the performance of labor of some kind, then those excluded have no claim at all to the means of their preservation. They merely have a right to use a common that no longer exists. As Grotius says, the right of private ownership would have completely absorbed the right which had its origins in the state of community of property. It is, therefore, only because Grotius understands private property to be conventional, and because he thinks we must consider the intentions of those who first introduced it, that he is able to say that a safety net should exist for those in direst need. Conclusion. It has been argued that the essential differences between Grotius and Pufendorf is their different conceptions of what using the common entails. For Grotius, there was a primitive right to take possession and use things to exclude others, while physical possession was maintained. Since this limited use of things can be understood as a series of lawful actions, it was protected by the natural right to personal integrity. No rights or obligations other than the ones all people are born with are necessary for people to live in a simple life of hunting and gathering. Consequently, no agreement was necessary. The introduction of private property gave the right to recover the ownership after possession was lost. Private property thus entailed rights and obligations that did not exist originally, and so an agreement was needed. Grotius was thus able to argue that God had given the world to men in common, and that private property had been introduced by agreement, without confronting the difficulties associated with the theory of positive community, and without the need for an agreement before the first men could make use of the world. The first use of the common discussed by Pufendorf required labor and storage. This more extended meaning of using the common, in which things were taken from the common for future use, required the creation of new rights in the things taken. Hence, some kind of agreement was necessary. However, Pufendorf's theory was not a repudiation of Grotius, but a defense of natural law position against the theory that private property rights had been conferred on the first man. Both authors, in stressing the gradualness of the development of private property, convey the idea that property has a history. Grotius's account has the additional feature of identifying a stage in history in which the use of natural resources were possible without taking the first step towards the introduction of private property. Men then had possessions but no private property rights. For Pufendorf, the history of property is from the beginning the history of conventions. These different conceptions were to be taken up in the next century and reworked under different philosophical premises by Adam Smith and David Hume. However, to explore these connections would go beyond the scope of this article.